destroy property. In other words, sell it and get rid of it in bad times. Mr. Hudnall, you are correct. This needs to be enforced. But the problem is that somebody else has control of this, a bank. Ms. Williams, I might suggest that you contact someplace like Rocket Mortgage or one of the equity firms and utilize them. They are much easier than a bank. They don't have all the constraints. You can get it done quicker.
Sir.
Yeah.
You talking about, you referring to her trying to refinance the house?
Correct.
Yeah, she's not going to be able to get it done. We've been trying this. We've been trying this.
Well, hold on. Here's what I'm going to do. Because the past 2 years have been hard to refinance anything because of the increasing interest rates. Banks have been less likely to want to. That's why I'm saying you might not want to go through a bank. What I'm doing is saying this will be enforced, but I'm going to give it another 6 months. But it's going to cost you. It's going to be a 4% simple interest rate, which means before this is over with, you'll owe him $62,400, not $60,000. Because his interest in the money is protected. Okay.
Mr.
Yes, Mr. Hudnall.
Why would I have to wait 6 more months for it to do this?
Because the financial circumstances make this, and what I'm doing is protecting your interest. That's why I'm correct. That's why I'm correcting and increasing how much she's going to owe you.
The 2,000, the 2,000 she would owe me extra, sir. It doesn't matter to me. I really would need my money to continue on with my life.
How much is the house worth?
Right now, this was going on with the house. No. The house only is valued at,
okay. Answer the simple question. How much is the house worth?
The house only valued at, like, if you look it up, it's about like at 290 something.
How much is owed on it?
70,000 only owed on it.
Okay. Ms. Williams, if you have that much equity, you should be able to get an equity loan.
That's what I'm trying. Can I talk, please?
Hold on. I asked her a question. Let me get the answer. Ms. Williams.
Thank you. That's what I've been trying to do with the situation of how he left.
What is your income?
Monthly or monthly?
What's your annual income?
I'll say it's about 35.
Okay. And you would need a $62,000 equity loan. What I'm trying to do is get you the money without having to sell a house, Mr. Hudnall, because then everybody loses.
I don't care about the house, sir.
You don't care about the house because you aren't living there.
Thank you.
I don't live there because I stayed there when I was living there, Mr.
I know.
But I got our son. I have to take care of our son. Yes. I got needs and wants. We got needs and wants. We've been going through everything.
I did too when you left.
Can I talk, sir?
For a whole year without you.
Can I talk, sir?
I don't think either one of you are going to talk at this point. Here's what the court is going to do. All right. As I started this conversation, we try not to destroy property, especially during bad sales times, because then it burns everybody.
Can I say something?
Give her. Yes, go ahead.
We tried to do all this. Well, I tried to do all this before.
Well, if you knew it was impossible, why are you asking for it to be enforced?
Because I have our son.
Yes, I know you do.
Okay, Miss Williams has not been helping me with our son. I've been having our son. I've been having our son since June 5th.
Okay, guys, I know we dealt with this 2 weeks ago. You have custody of your son now.
I have something else amongst that I need to tell you about, sir.
What's that?
Remember, I just had you put in the motion, basically,
right?
As far as for just our last time we was on here, and I had you put in the motion for her not to collect the FOC money, the friendly court money, right?
Well, because he's about to turn 18, and we're done.
Okay, now what she won't do. It was a previous bill. Now, remember our last time we stayed, we already on the record that he's been staying with me from June 5th,
from June,
right? Since he's been out of school. Okay, they trying to charge me. They trying to charge me with June and July.
Okay, well,
he's been living with me. He's been living with me ever since then. He's never been on. He don't go on any home visits, any night stays with her. None of that. He's been staying with me ever since June 5th, since he's been out of school, sir.
Okay,
he don't do any home visits. He done no business.
Can you let me fix that problem?
Huh?
Can you let me fix that problem?
That's all I'm asking you to do, sir.
All right, I'm going to fix your problem and try and fix both of your problems and get you the money. Okay? So let's do this. I'm going to waive all arrears, waive any and all arrears.
Did you put in for like June and July? Because that's what they said.
Any and all arrears. Anything you owe is going to be waived.
Okay, thank you, sir.
All right. I'm going to give her the extra 6 months, but with this condition, it has the 4% interest rate, which I believe takes the amount owed to $62,400. Ma'am, if you do not sell it in 6 months, then I am selling the house. We're going to give you a chance, but you did sign an order saying that you would pay him on November 1st. But what you're telling me is that there's an impossibility in doing that right now. I'm giving you another 6 months. I'm protecting his interest in this because he was owed $60,000 as of November 1st. So it's going to have a 4% simple interest rate that'll be owed to him. So if you pay it in 2 months, that's not going to be $62,000. That'll be $60,000 plus 4% for 2 months.
So what if she don't pay me for the 6 months?
I told you that I'm setting this for a settlement conference where I'm going to reserve the right to order the house to be sold. What I'm trying to do is protect both of you. Okay?
But sir, but what if I think I'm just saying, Mr. Kmetz, we gave her 6 months last time.
Okay,
and you just told me that it was you tried and it was not possible.
No, so I didn't try. We tried this, sir. We tried all this beforehand. Miss Williams will not be able to get no loan. She won't be able to get nothing off of the house because of all the previous things.
That's why at that time, what I'm going to do is we will increase the amount that's owed to you, and I'll sell the house if she doesn't pay you.
But the only thing I'm saying, sir, I got my child. Me and my child, we goes back. I goes back and forth. The Lancer with them at times and days. It's days I stay with them. We're here in Grand Rapids with family.
Yeah, that was part of the custody deal. This is a property deal.
Say that again.
That was part of a custody deal. This is part of the property deal.
Okay, well, then
they're two separate issues.
Do you handle any part of our custody deal?
Did I what? I gave you custody. I gave you custody.
Okay, I was just wondering. But since I've had custody of them, when she had custody of them, I had to pay her all the way up until June 1st.
And when we talked about this, because that's when you had him, and I'm going to erase anything that you owe her from June 1st.
Okay, so what help would I get then? What help would I get from her from him? Because she don't help.
We talked about that. We talked about that 2 weeks ago. You said you didn't want anything because he's about to turn 18.
I know she said she didn't want anything. I need help with it because my son.
No, you said no. I rewatched the hearing. You said you didn't want to deal with it. You just said set it at 0, which is what I did. I did what you guys agreed to.
No, I didn't want to deal with what I was trying to deal with.
Can I talk to you for a second?
No, we're both done here. I'm granting what I'm granting. I'm dismissing the arrearages of anything that's owed back to June 1st. I am going to grant the 6 months extension with a 4% interest rate. Ms. Williams, I would suggest you stop working with the banks and work with an equity firm who will be a little bit more giving you equity, especially if there's 130,000 and you only need 62,000. Okay?
Thank you.
Have a good morning, both of you. Good luck. This is not time to argue, folks. It's time for me to help you get through this. Okay, it is a time for them to argue. Never mind. Just not that way. Oh, and I put my notes in that file. That was a nice way to start the Friday morning.
Yeah, that's what I was thinking.
Yes.
Ashcraft versus Ash.
Hi.
Good morning.
Good morning.
Okay, Nathan, did you connect?
I did.
Right.
Good morning.
Okay, we're here in the matter of Ashcraft versus Ash. Trying to figure out the best way of getting both of you through this.
Okay.
The request that you've made is rarely granted, the waiver of the 6 months, but you do have all of your paperwork done and signed. But the law says I can't do anything until 60 days has elapsed from when you filed, and you filed on October 8th.
Oh, okay.
So no matter what, my suggestion procedurally, I'm going to deny this. You may then object to that, and that'll get you in front of the judge and see if she's willing to. But normally what we need is some kind of exigent circumstance or, some emergency that would require the deleting of the 6 months. But that doesn't prevent you from at least making the plea.
Okay.
Okay.
Yeah.
But I can't do it before 60 days at all.
Okay.
What I will do is I will put in a denial order that you will have the right to object to, and then the judge may hear it, and by the time she hears it, the 60 days will have lapsed.
Okay. Yeah, I didn't know about the 60 days. Thank you.
Yeah,
I knew
no, but that's pretty much statutory. It's a minimum. It's 60 days for divorces without children, 6 months for divorces with children.
Okay.
But no less than 60 days can proofs be taken, which are the testimony to enter the judgment.
I see. I
So
see.
the only thing that I know of is if I concur with my clerk, I know the judge is going to be gone for a couple of motion days on vacation, so it may delay it a month or so. But like I
Sure.
said,
Understandable.
because you don't want me to hear it again, because that's all I'm going to do is deny it again. Uh,
Hmm.
so, but that may be the simplest and easiest way for you to do this.
Okay.
Okay. That
Thank
way
you
you
for
get it
that
addressed
advice.
sooner. Yeah, because I mean, I love the fact that you've agreed on everything and everything's signed and everything's willing to go. There was another statute you could have filed this under,
Oh,
which was a
no.
petition, but even that has the 6-month waiting period.
Okay. Okay. Got
But
it. Okay.
it never, the worst you can do is ask and be told no.
Sure.
Yeah.
Yeah.
So,
Yeah.
I mean, you've got everything
Makes
done. It'd be nice to get done before tax season. And maybe
Mhm.
that's a good reason is taxes may, because of your circumstances, be a problem.
Okay.
All right. But in any
Thank
event, because
you.
we are running up to December 31st.
Yeah.
Yeah.
Most people forget what an important day that is, especially in divorces and marriages. People get
Sure.
married on New Year's because then you're married filing jointly and you get better tax benefits. People want to get divorced before December 31st because they don't want to file that joint taxes with anybody.
Okay.
Right.
All right. Good luck
Okay.
to both of you, but at this point I have to deny it. I apologize.
That makes
That's okay.
sense. And I appreciate you talking us through
No
all
problem.
that.
No problem. Like it's a procedural issue and it might get you seen sooner. I
Okay.
can't
Okay.
tell you what to argue. I can tell you, but I can tell you that procedurally might be the quicker way.
Okay.
All right.
Appreciate that.
Have a good morning. Good luck to both of you.
You
Thank you.
too.
Appreciate it.
All right. Take care. DC. I've read your motion, Ms. Chapman. Mr. Chapman, Ms. Glover, Mr. Chapman, I didn't get a response. What's your thoughts?
I disagree with the makeup time. I
Why you
don't,
don't want it?
yeah, I want the makeup time, but I want it
Okay.
to be the 2 days or the 3
So
days.
you want, let's see, your son is got a
Daughter.
prognosis. Okay. Your child has a prognosis of a brain tumor.
No, not my child.
Okay. Oh, okay. That's where I'm confused. I thought this was also your child.
No.
Okay. All righty. So her brother is the
Yeah.
one with the brain tumor. That is a child from another father, correct?
Yes.
Okay. Miss Glover, prognosis on your son? How
He
much
has
longer?
well, right now they decided to end chemotherapy due to his cancer coming back in
Right.
his brain and his spine again.
And he's already had enough chemo.
Yeah, he's had enough
So,
chemo, enough
well,
radiation.
that's why I'm asking what the prognosis is. How much longer?
We don't know.
Okay.
Yeah, she didn't have a time frame or a date or anything.
Is he in a wheelchair? Is he able to ambulate?
Yeah, he's in a wheelchair. I mean, he can get up and walk here and there, but the wheelchair is necessary just because he has pains in his back and his legs and stuff. So.
Okay. Mr. Chapman, your daughter has a relationship with this young man, correct?
Yes.
Okay. How would she feel if she didn't get to go on this vacation that's being offered to them by somebody else?
So
If she didn't get to spend her last moments of fun with this young man?
I don't object to her going.
Right.
I'm saying I don't have a problem with her going. Whenever I make up my days, if it's 2 days that I'm missing,
Right.
I would just like to make up the 2 days. If it's 3 days that I'm missing,
Oh yeah, yeah.
I would
That's
make
why I
up the
asked you.
3 days.
You're getting to make up days. I mean, yeah.
My understanding of this motion is that the makeup days be split up.
Okay. When would you like them? How would you like them to happen? What's your suggestion? Because like I said, I didn't get a response from you. What is your suggestion on when you get the makeup days?
Whenever she comes back, the next time I get her, I just keep her the additional days or whatever.
Yeah, okay. And Ms. Glover, because you're going to have her for an extended time, Mr. Chapman should be able to have her for an extended time as well.
Well, I would like to further state, Your Honor, I often take trips and miss time with my daughter. Ms. Glover is never.
Mr. Chapman, that's why you have the right to file the same motion she just did. There are times the court is going to say, look, you can take an extended trip and the other side will get time back. I don't like to keep children from having an experience that they otherwise wouldn't have. And this is a heck of an experience because of what her brother is going through. They're being offered a trip that is going to be fully paid for by someone else.
And I don't object to that.
Yeah, well, and so, yeah, but if she won't cooperate, you have the right to file the same motion that she just did.
I understand that, Your Honor, but my experience with the courts in this case hasn't always gone
Well, you know,
in a reasonable way.
Well, the court generally follows the law, and that's sometimes reasonable depending upon what side of the law you're standing on. But you know, the reasonableness of the law in this case is pretty standard, which is we're not going to interfere with the kid's trip, and you're going to get back the time. So I'm going to grant the motion to go on the trip. And yeah, if you show me that, you know, you're going on a cruise or something that it would interfere, there are moments that we will adjust. Sometimes we can't, sometimes we can. Now she's doing okay in school, right?
She's doing halfway decent in school.
Yeah, she's not doing so well.
Is she missing school for this?
She will.
Okay. Make sure that you have all the homework assignments and everything set up front.
Okay.
Trust me, I had my kids sitting in a Disney World hotel many times doing homework when we took them out of school for stuff like this.
So when will the makeup time?
It should be the week after or the week after that. It's going to be within 2 weeks of the trip.
Okay, so that's why I filed the motion, because I was requesting that the makeup days be like separate. Janasia never spent longer than 3 days away.
I understand that. But no, she's going to spend longer with you this time. She gets to spend longer with her father.
Well, I'm not saying she wouldn't. I just was asking that it be separated because
no. I said no. I said he's going to get the days back immediately, either the week after or the week after that. So it's all going to be within 2 weeks, but he's getting them straight.
Okay.
Okay, that's the consequence. You know, if you're going to remand somebody's parenting time, they're getting it immediately back.
Okay.
Under these circumstances. Okay.
Okay.
So I'm granting your motion. You may take the child under the facts that, you know, you make sure that she's got the homework and assignments done, and the fact that he gets to make up time either the very following week or the week after that, but immediately.
Okay.
All right.
Okay.
Yeah, that's the consequence. Sorry.
Yeah, true.
Consequences both ways.
Yeah.
Like I said, the law it works reasonably depending upon which side of the fence you're standing. Right?
Yeah.
Okay.
Who determines when the time is made up? The first.
Well, I'd like to see if we can do that before we leave. What are you saying? And now that you understand the circumstances, Miss Glover, should you do it immediately after? I'm sorry, Miss Glover, under the circumstances. Well, Mr. Glover, Mr. Chapman, which days do you normally get?
It rotates 2, 2, 3.
2, 2, 3. So you just want 4 straight.
If she's gone for 2 days that I miss.
Why don't we just cut it and call it, let's do it the second week she's back. That way she gets adjusted for school under the normal schedule.
Okay.
Kind of gets her feet straightened out. The second week that she's back, you get 4 straight days.
I don't have the dates in front of me.
Yeah, what dates, Miss Glover, are you going?
Through the 3rd through the 7th. So we leave on the 3rd and we come back on December 7th, which is
okay, December 3rd through the 7th. Okay. So that would be, let me see if I can pull up a calendar. So where are you staying? Do you know, Miss Glover?
Oh, I don't know yet. I think they gonna kind of get with us today to kind of go over everything and all the arrangements.
Wonderful.
Yeah.
Wonderful. Okay. Let's see, December 3rd through the 7th. So the following week would be the 9th through the 13th. So we're talking about the 16th through the week of the 16th through the 19th. What are your 2 days on that week, sir?
I'm trying to see right now. So I have her on the 9th and 10th.
Okay, next week.
And she'll be gone from the 3rd through the 9th, or the 3rd through the 7th. So yes. I'll miss 2 days. So I would get her back on the 9th.
And 10th. And that's the week I'm saying just let that be a normal parenting time to let her get her feet.
Normal parenting time.
Get stabilized. The week of the 16th, what days do you have?
I have her the 18th and the 19th.
So you should get the 16th and the 17th.
Okay.
All righty.
18th and 17th.
Well, no, I'm sorry, Your Honor, that's wrong. I have her the 13th, 14th, and 15th. Then I don't have her the 16th and the 17th, and then I have her again on the 18th and the 19th.
I understand. I'm giving you back the 2 days you lost as the 16th and 17th.
Okay, so, all right, so
Because you
I'll
normally
keep
would have the 18th and 19th, the 16th and 17th would be
her mom.
her mom. And so you would get the 16th and 17th, which would be your mom's days, to replace the 2 days that you lost during the week that they're gone.
All right, so I'm gonna just be fair and say that would make me have her for 1, 2, 3, 4, 5.
I understand.
Okay, I'm fine with it. I just
Yeah,
want
I know. And mom's
mom.
gonna have her for some extra time too. So I know it's not perfect, but we want to get it done and not have it lingering out there. Okay.
No, I just want clarity with mom, so there's no
Yeah.
problems moving forward.
Yeah.
So
And
we
I
understand.
think mom understands. She wanted it split up a little bit so that didn't happen, but that's the
Yeah.
way it's going to happen because you get your days all conglomerated. He'll get his days all conglomerated. Same thing for both of you. Trying to treat you as equally as I can. Okay.
Thank you.
Good
Your Honor.
luck. Take care.
Thank you.
Have a fun trip. Be safe. Thank you. And welcome
Thank
as
you.
always. It's been
Thank
a
you.
while though.
I know.
It's good to see you again, sir.
Thank you. Thank you.
All right. Ms. Cole, this is your motion. You may proceed. We'll try and do this one sentence at a time.
Excellent, thank you. My client filed this motion to change parenting time based on her understanding that the party's 12-year-old daughter does not feel safe at her father's home. There is proper cause to change parenting time, and it primarily arose from an incident described on October 12th, where the 12-year-old daughter walked to her mother's home in the rain at 2 a.m. However, my client also has multiple additional concerns about the living arrangement at her father's home. First, it's her understanding that the child shares a bed and a basement bedroom with her father, and she has no privacy. She's almost a teenager and should have her own place to sleep, and she really needs a space to herself, especially at this age.
Is that really the biggest concern you have on this situation?
Ese-
It is a large concern of my client, yes.
Wait,
sí,
wait,
es
wait.
una preocupación mayor de mi cliente. Sí.
Wait, what about the other allegation? That seems to be the bigger time bomb here.
Y aquí.
Absolutely. The
Oh,
incident,
okay, let's go with the big one, please.
Muy bien, entonces vamos con la mayor, por favor.
sure.
I'm not as concerned about the living arrangements that have been going on for years before this happened. I'm concerned about the bomb that just went off.
So on the incident, which occurred on October 12th, the 12-year-old daughter was with her father and family. And it's my client's understanding that the daughter did not want to sleep in bed with her father on that night because he was drunk from the party. My client informed me that her daughter was uncomfortable being there, that she did not want her father driving, that when she put up when she voiced concern for him driving home, that he berated her and told her that he is going to do what he wanted. She asked to sleep over with her cousin and she was not allowed to. And when she got the opportunity, when her father fell asleep, she ran to her mother's home in the rain.
Y
at 2 in the
cuando,
morning.
Did he wind up driving home that night?
él
No.
fue el que manejó a casa esa noche.
Okay. Ms. Jimenez, your client got drunk at a wedding, correct?
Señora
Yes.
Jiménez,
When his 12-year-old daughter confronted him when he tried to drive her home, there was an argument, correct?
There was some argument going on as to what happened, but he ended up not driving, Your Honor.
hubo un
Because of the
argumento.
interference of his mother and sister?
It was his sister's wedding.
Okay, but didn't other female members of his family intervene?
I believe so, Your Honor.
Yo creo
And
que
when-
sí, su honoría.
And when they got home, there was another argument, correct?
Oh, I don't believe that's correct, Your Honor.
You
Yo no
believe that
pienso que
this,
eso fue correcto, su honoría.
you believe that this child did not have any problems once she got home and or walked in the rain to her mother's house at 2 a.m.?
¿Usted
She
cree que
was
esta niña no tuvo
upset.
problemas cuando llegó a su casa y se fue salir de la casa a las 2 de la mañana? Ella estaba molesta.
He was upset because he didn't give her permission to sleep at her cousin's room upstairs in the same house.
Because
And
she
then
didn't-
when,
Because she didn't want to sleep in the same room with a drunk guy who had been yelling at her?
Your Honor, I've explained to my client what needs to be corrected here. He's already bought a bed for her and he set up a bedroom for her.
Él ya compró una
CPS
cama,
went to the
ella
house
hizo una cama para ella y también la Agencia Protectora de Menores
and checked everything.
When did CPS come in?
fue y checó todo. ¿Cuándo fue que CPS fue?
Tuesday. This Tuesday.
el martes pasado.
So he's corrected that situation.
When was CPS involved?
I don't know who called them, but they found out about the situation and they went to his house. Yeah, and the other thing, Your Honor, my client is willing to comply with the no alcohol provision while
Cliente está
parenting.
disponible
So,
con el
her
tiempo mientras
concerns
esté
can be
bajo su
remedied.
protección.
All right, here's what we're going to do.
Las preocupaciones pueden ser remediadas.
In accordance with the pleadings and response and situation and police report, there was an act of domestic violence committed by the father upon the 12-year-old daughter. Thank goodness it was not physical, but it was mental and emotional. We are now dealing with a very traumatized young lady. The bed was one issue, but it was not the main issue.
Pero no fue el tema principal.
There's indicia from the case file and pleadings that this is not a one-off incident. So I am going to suspend his parenting time currently. We are going to meet in 4 weeks for a settlement conference. I intend to get his parenting time back to what it was, but first we're going to deal with this traumatized child and have her feel safe. So if we can, I'd like both attorneys to try and get a contact of CPS. That way we have an understanding of what's happening in 4 weeks, because now that they're involved, I need their input.
Punto de vista.
I don't believe they're going to open a case, Your Honor.
And that's what I need to know, but I want their input.
Okay.
Yo pienso que va a haber un caso. No pienso que va a haber un caso, sería, está bien, pero necesito saber ellos qué piensan, su punto de vista.
Their input would also be necessary to assuage the mother's fear that this child does not have proper living conditions. It would benefit both parties,
Esto será de beneficio para ambas partes.
but most importantly, it would benefit the child. I also want to know if they may be able to offer services to this child for counseling or something to assist her in getting over this trauma. I realize teenagers can be histrionic, but this sounds like it was based on an actual event that shouldn't have happened. And then we'll deal with the no alcohol provision during parenting time as well. There are consequences for an event like this, but we will move it on as quickly as possible, deal with the trauma quickly, because I don't want it setting in and the child not wanting to go back, because over time we've withheld her from the father completely.
Okay.
All right, so this is a Band-Aid
Esta es un curita nada más.
to find out how deep the wound is and how quickly we can heal it. Have a good morning, everyone. I'll see you in 4 weeks. And Ms. Cole, you may draft the order for suspension, temporary suspension of parenting time.
Entonces, que tenga buenos días. Y si me acuerdo, tengo una orden de suspensión temporal de los derechos del padre.
Are we gonna get the date in the mail, Your Honor, or you have a date?
You'll get the mail. You'll get the date shortly.
En un ratito le darán la fecha.
I try not to have my clerk deal with that kind of stuff in the middle of motions when she's dealing with all kinds of things in the background. She's getting all the emails and all the chats and all the other stuff, so she's busy enough.
Está ocupada con todo lo demás, correos electrónicos y cosas de ese tipo. Tiene
Thank you, Your
suficiente.
Honor.
I'm just glad we have
Gracias,
two
señoría.
competent. I'm just glad we have two competent attorneys that we can get this through quickly.
Thank you, Your Honor.
Thank you.
Gracias, señoría. Thank you. Thank you, Your Honor.
Have a great day, Mr. Castillo. Good to see you again.
Thank you. Yeah,
Ms.
nice seeing
Jimenez,
you.
Ms. Cowell, good to see you too. Take care, everybody. Look
Bye.
forward to getting you through this all.
Bye.
All right. Take care. And yeah, Rebecca, remember, we're gonna have to order a translator for that. So,
Yes, thank you.
Yeah. Okay.
Okay,
Yeah,
we can
sitting here
do,
going, you're dealing with the bed, and I'm sitting here going, this guy laid into her while he was drunk after a wedding,
yeah,
and for like over an hour, according to the reports. I'm like, with intervention of family members. Like, this isn't pretty. Sorry, I tried to nip that in the bud. Anyway, next.
Yes, I'm connected.
Next
How
we
are
can
you
do
today, sir?
Davis
Wonderful.
versus Adam.
Good. How are you?
I'm okay,
It's Friday morning.
considering.
It's Friday morning. It's the 5th Monday of the week. Yes.
It's Friday. Obviously, this whole situation has me nervous.
Then what I'll do is do my best to explain the law and see how we proceed. Mr. Block, I know you connected. Welcome.
Good morning.
All right, let's go ahead and go on the record of the matter of Davis versus Adams. All right, I have the motion from Mr. Block. The first thing is it's an objection to the front of the court, so therefore you're going to get a hearing. And I'll explain
Correct,
the
yeah.
consequences of that. But under the circumstances, how often, Mr. Block, has your client seen this child?
He has not seen her
So
at
after
all.
a year and a half, he's never seen the child, and the child does not know him.
That's correct.
Okay.
He has tried.
I understand he has tried, and ma'am, he's the father, so he's going to see
I
this child.
understand, and he actually has not tried. The reason
Well-
that the friend of the court made
Well,
the response they did.
We're here because he is going to try. Okay.
That's
I just
fine,
have
and
to,
I've
I
been
just have to
open to
figure out
that,
a way
but
to, is there anything you would suggest, Ms. Davis?
I did suggest when we spoke to Mr. Bosworth with the friend of the court that
Right.
we try to meet. He tried to say that he contacted me 3 times. I actually sent my phone records to the friend of the court to prove that he did not do that. So him saying that he did it 3 times is just blatant lie. I was at that time willing to try to just meet with him, but he's
Right.
shown that he's not willing to put in that time. And I think
Okay.
Journeys is the only way for him to properly get to know Maggie. I
Okay.
cannot make a decision as to whether or not he is able to care for her on his own.
But you're willing to meet with him and the child?
I was, but
Okay.
after the last 6
After
months,
this, okay.
yeah, I was
Uh, uh,
wholeheartedly willing,
uh,
but after this, no.
Yeah. And Mr. Block, I have a question, because normally we would start this with professional supervision. I understand your client has some problems. The reason it was probably sent to Journeys is because Journeys has that grant that pays for it up
Yep.
front.
I guess
Any
I was not, aware of the grant. I mean,
Well, I have to trigger it if I send the order to send it to Journeys.
It was triggered. He was asked to contact
Well,
Journeys
no,
within
I don't
21
have,
days.
I understand, but there is no court order and they normally require a court order for that.
Yes, sir. Okay.
Okay,
guess, you know-
that's where I'm confused. The front of the court recommended it just because the recommendation is out. It never became a court order because it was objected to.
I understand.
And in it, I don't see the requisite order of reference to Journeys for the grant to be triggered. So how about we do this? How about I send that order to Journeys to trigger the grant, Mr. Block? Okay. And then we're going to meet in about 6 weeks to see how that went. The idea, Ms. Davis, is once he gets to know the kid, and more importantly, once the child gets to know him,
Sure.
that there's some comfort level, we're going to start increasing that somehow.
Yes.
So what I want you to think about, Ms. Davis, is what would you feel comfortable with in trying to advance that if you want someone around, like maybe his mother or someone like that, someone you trust in his family. I mean, you chose him as the father, so obviously I'm not deleting that. What I'm trying to do is move this along because eventually he's going to get standardized parenting time. But
Right.
we need to
I understand
advance
that.
it in such a way that it can be done appropriately and safely. Mr. Adams, this isn't going to be easy. I've got to undo a 1.5 years worth of no contact. And it doesn't sound, even the front of the court says that they had a problem contacting you. That's why their recommendation was what it was. So you may be saying you're doing things, but there's no evidence that you're doing anything. It just sounds like you're sitting back and wanting to blame others and try and say that you're doing something. Well, I'm going to reissue this Journeys thing and try and get it done through the grant. Okay. There may be some cost to you, but I'm going to try and get it triggered through the grant. That way there's minimal cost to you. Mr. Block, there's no evidence in the file of any healthcare issues of your client. None. Okay. So we're going to meet in about 6 weeks to figure out how that went and can we start to advance it. And I'm going to grant you a trial. I'm 90 days out anyway, so we'll give you a trial date just as a backup. All right. But I just want something done between now and then. And the way we do that, Ms. Davis, is, as you said, through professional supervisors.
Yes.
And, that's the best way I can do this. And Mr. Adams, that's a protection to you and something good for you as well, because then we have a professional supervisor saying, hey, this interaction went well. He's a good father. He interacts appropriately. Okay. That way you've got somebody that has a professional air about them to do this. I realize.
And that was what I was requesting.
And that's what the court would grant. And I understand, Mr. Block, this is going to be under poor circumstances. I understand his income may be minimal, but again, the court doesn't have any evidence that the initial child support order was for $1,000, and it's down to 700 and something.
It's actually down to 483, and
Yeah,
he still hasn't. He hasn't paid any.
Right,
he's paid $50.
Yeah, I understand, but he's also saying that there's a heart condition and some medical conditions that prevent him. And do you know of those, Ms. Davis?
I do. He does have a heart
So-
condition, but it never kept him from working before.
Well, age does do things to people.
Right.
And so do certain conditions. They diminish them in their capabilities over time.
And he's
Even,
yes.
even younger one. What,
he's
Mr. Block?
also developed IBS, and
Oh,
that
great.
made it
He-
very difficult. Hold on, let me
Yeah.
finish. Miss
Well,
Davis.
yeah.
Yes, sir.
And he advised me today he is not able to work at the moment.
Well, I
no
would
income.
suggest that maybe, are you going to work with him on applying for disability then?
That has been my suggestion. I know he's waiting to see a doctor. It's been hard to get in to see a doctor.
Right. So we will deal with all of those issues in 6 weeks, and hopefully we'll have some benefit of having Journey say, Miss Davis, that he, he's met the child, the child's met
Yep.
him, and the child's okay with him. We
Yeah,
got a young enough, we've got a young enough child that the child's a little bit more malleable, and then the child's old enough to actually kind of walk up to him and start to
Right.
establish a relationship.
Sure, exactly.
So let's see if we can get this going, and we're going to move it on so that both parties are aware we do eventually get to normalized parenting time. And if he applies for disability and gets that, that's not a bad thing for both parties.
Mhm.
And there's a consistent income that is drawn from. All right.
Okay.
Unfortunately, it takes up to 2 years to get disability.
Yes.
Good luck.
Can I ask one
Sure.
question?
Sure.
In the meantime, what happens with, this arrears that keeps getting bigger and
It keeps going until we try and figure out and file, Mr. Block, I'm sure will file the appropriate motion to preserve a date to say,
Mhm.
look, this disability is just now here and there is no money coming in.
Okay. I'm
Generally,
curious. Sorry, go ahead.
Generally what will happen is he does apply for disability. The application date is preserved there as well.
Sure.
And the money goes back to that application date, and therefore the arrears, while accumulating, can be paid off by that backdated check.
Okay.
The child gets one. The child gets one too.
Okay.
One other quick question,
Sure.
referee. Can you ask Ms. Davis, is she living at the Francis Street address?
Is that where you're living, Miss Davis?
Yes, I've lived there for 15 years.
Oh, okay.
Because there
That's
is
pretty stable.
a registered sex offender that's living there.
No, there's not. He
I'm
hasn't
not-
lived there for 3 years.
Okay. And
It's,
again,
this is a moot point that we keep bringing up.
I'm taking the parties as they are right now. Right now, she got him the way he is, and he got her the way she is. I mean, bottom line, they chose each other as parents here. I'm going to deal with them as they sit. So we're just going to move them along and see if we can get this child appropriately to know both of the child's parents.
Are you going to give us a date now for the 6 weeks out? Or
No, as I just explained to somebody, my clerk is dealing with all kinds of things in the background, and I'm not going to have her start hunting up things because she's dealing with emails and chats and all the other stuff that's going on with all the other parties that are waiting.
Very well.
All right. Mr. Block, good to see you. Ms. Davis, nice to meet you. Mr. Adams, nice to meet you. And hopefully we'll get you both through this. Well, actually, all three of you, both of you and your child.
So I just wait to hear from you guys then?
Well, you could be getting an order from Journeys. I'm sure it'll have the contact information on there, and I'm sure Journeys is going to want you to contact them. And Mr.
I
Adams,
did contact them already.
And again, they probably didn't have an order to do so. So I'm going to make sure that order gets put in place.
Okay.
Okay.
Okay. Thank you.
Take care, everybody. Good luck.
All
Nice
right.
to see you.
Thank you.
Thank
we'll
you.
get you through
Bye-bye.
this. It'll take more time than you'd like, but sometimes less time than everybody would think would be necessary.
One last question.
Sure.
You want me to do an order on this, or is that unnecessary?
If you'd like a backup order, I'm just doing an order of reference to Journeys.
I think
Because
that's
I'm holding off on the front of the court recommendation, which was recommending Journeys. But I'm like, how do you do this without an order? So I'm like, the objection actually may have slowed some things down. So let's see if we can speed them up.
I'll submit an order.
Okay, no problem.
Yeah, of what was said. Okay.
All righty. Take care, everybody.
Thank you.
Have a good morning. See you soon.
All right.
All righty. And I put my notes in that file again. I hope they're there. I gotta stop putting my notes in other files. All right. Did you file this motion, Mr. Kina?
I believe she did.
Okay, that's what I
was
thought.
going to.
Yeah, and technically you should, or at least, because bottom line, this is a prosecutor's case. The prosecutor of the state of Michigan the prosecutor for Kent County filed this case on behalf of the state of Michigan. Neither one of you filed this case. So the prosecutor needs to be invited to this motion.
Oh, okay.
All right. Because it's their case.
Yeah,
They have input.
that makes sense.
Yeah. Yeah. And they just entered this order on October 9th. So
Okay.
it's the ink's barely dry. They should have input here. Sometimes they'll help you out too.
Okay, because I got a call about a bench warrant, so I was hoping.
Why would you get a bench warrant this quickly? The order just
I
went
don't-
in.
I'm not sure.
Yeah, that's weird. What you may want to do is kind of file the motion, renotice this motion, but file a concurrent motion that you're asking for it. Because technically she doesn't have the right to ask for this. She knew you weren't the father.
Okay. All right.
It's basically, my question to her is going to be, so why'd you lie to the prosecutor?
Yeah.
No, wait a minute. Never
No,
mind.
we're still married.
Well, you're
We're still
married.
married.
That's
Yeah,
right. Never
yeah,
mind. Because
yeah.
that's not in the file.
Yeah.
I do. Okay. Sometimes I get a little confused when I get 20 or 30 of these on a Friday morning. But yeah, no, you guys are married. Are you still married?
Yes, technically.
Okay,
Yeah.
please file a divorce.
Yeah. I'm trying.
Because she gets pregnant again, it's yours.
Yes, exactly.
All righty. But you file basically a counter motion response to this, and make sure you invite the prosecutor.
Okay. Okay.
All right.
So nothing can be done without the prosecutor.
Well, I can do some things, but if they're invited and don't show up, I can move on. But if they're not invited, I can't do anything.
Okay.
Referee,
Okay. Yes.
may I say something? I don't know if you
Sure.
saw my chat.
No, I did not.
Okay, this case was previously scheduled for a prosecutor motion last motion Friday.
Okay.
And because Ms. Rummelt saw that there was a motion scheduled for today, she adjourned her motion last motion Friday for you to rule on this. So she is aware of today's
she
motion.
is aware. Oh.
Okay.
Ugh.
Yeah.
Okay. Then
No,
maybe hold on. Maybe what I do is I'm going to schedule a quick hearing on this and invite everybody myself.
Okay. All right.
Because I don't want this lingering. Then if Margaret is very aware of this, then let's invite Margaret. Miss Rummelt is the prosecutor that represented this case from the prosecutor's office. So what we'll do is we'll set a hearing. I'll invite you, Mr. Kina. I'll invite the mother, and I'll invite the prosecutor. That way we can just nip this in the bud and get this done.
Okay.
Because it's obvious you're not the father, I think, because
it's obvious.
you guys have been separated long enough that you haven't been with her since you separated, right?
Exactly. No.
Okay, in that case, if you ain't been physically with her since you separated,
there's no possible way.
I don't think this can possibly be your kid. Although, believe in miracles.
Yeah.
In any event, we'll set this for a hearing then.
Okay.
It'll be a quick half hour. I'll bring in everybody. We'll put everybody on the same page and see how we can get you both through this.
Okay.
And then hopefully I'll invite Miss Kina and she'll show up because she didn't show.
Yeah. I don't know what's up. Yeah.
Yeah. Who knows? All right. Let's get you through this.
All right. Thank you.
See you soon. Take care, Mr. Kina. All right.
Bye.
I'm tired of having kids have fathers who aren't theirs be listed as fathers. Thank you. When I first pulled up the chat, it was blank. It just all filled in.
What? Okay.
Yeah. I don't know why. It says you started it no, the 9:10 one I got. But the one from the other chat I did not get until it just showed up while we were talking.
Hello.
All right. Oh, good morning, sir. Can you identify yourself?
Yes, I'm Carl Gordon.
Mr. Gordon, welcome. Welcome, Mr. Gordon. My question to you was, have you ever seen the child? Have you ever met the child?
Yes, I have.
Okay. How many times? When was the last time you saw the child?
The last time I saw the child, what is it right now? November. Maybe September.
Okay. So you've seen the child off and on, just not consistently. And it's because
not
she's
not
right. She's not
consistent.
helping you. All right. Let me try and explain the procedure here. I'm going to send this to the front of the court for that parenting time. The fees are going to be waived because your fees were waived by law. Okay. They're going to meet with you. They're going to meet with her, and they're going to make a recommended order on what your parenting time should be because you will be getting parenting time.
Okay.
Okay. Be prepared to give them your work schedule. Okay. Because they need to know when you're available.
Okay.
She should hopefully be able to give them her work schedule. That way, and how old's this child? Not very old, about a year and a half,
11.
2 years. Oh, this child's 11? Okay.
Yeah.
All right. I'm sorry. The case is a 22 case brought by the prosecutor, and normally they bring them within a month or two of the child being born. So we've got an older child. So this should be pretty. How far apart do you live? Do you know?
Around probably like 15 minutes
Okay.
from each other.
So you guys are close together, close enough together that that distance shouldn't be a problem. So let's get this going. Okay. Now, the reason I sent it to the front of the court is because they can hear all of your desires and wants, and, you know, the rules of evidence don't apply. If you're in a hearing in front of me, the rules of evidence will apply. So it's easier for you to get through them
So
what you want.
I have a question.
Sure.
It probably much don't pertain to what's going on, but since I could talk to somebody today, I want to say what I have.
Okay. Okay, go ahead.
So the fees and the child support that I have been paying her, will that somehow be reimbursed? Because, like,
No.
you know, okay.
Why would it be reimbursed?
I mean, because why am I paying if I don't?
Because you're paying, because the child under law requires to be supported by both parents financially. She's supporting the child automatically financially because most of her money is going to pay for the child. You're paying a whole $155 a month. That barely covers food.
Okay.
But it's also supposed to help cover for a roof over the kid's head and clothing and some other things. So no, you're not going to be reimbursed. Now I can, because of the timing, I can add child support to this. You can have parenting time and child support be reviewed if you would like.
Okay.
Do you want it reviewed or not?
No.
Okay. I was going to say, just be careful, because once I fire that bullet, I can't put it back in the gun. But parenting time is what you're here for. So what we'll do is we'll send and the parenting time that's normally assessed, child support's based 99% on your income.
So if that law is broken, then what?
What law?
Like, what if I'm still not able to get my parenting time? Because is she aware of this?
Is she aware of what?
What's going on today?
I don't know. You're the one that was supposed to notify her. Are you telling me she doesn't know? You didn't mail this to her?
Yeah, I did mail it to her.
Okay, then that's all you needed to do, and she should be notified of this, because that's what the law requires, that you mail it to her so that she's notified of this, but she didn't show up, and this matter was set for hearing at 8:30. It's now 9:34. So without her presence, this is your motion. I'm going to grant your motion and send it to the front of the court for parenting time.
Thank you.
Okay, and once that parenting time is recommended and ordered, then we'll talk about if she's violating that order. Just as we talk about if you don't pay the child support. Violations are violations of court orders. Okay?
Okay.
Good luck. Take care.
Thank you.
You have a good morning. I'm sorry, it's going to take some time, but I can't undo what you guys have done for years on a Friday morning. It's nice to meet you, Mr. Gordon. Good luck with this. 771. All right, next. For the record, Mr. Hunterman sent an email to my clerk yesterday saying that he could not make it due to job obligations this morning, but he did have some explanations.
Okay.
The first one was the car wasn't stolen. I think he thought it was, but it was repoed.
Right. Yeah.
Okay. So that doesn't obviate the fact that he needs to hold you harmless to that debt. I don't know if you can refinance it at this point. I think that overrides the refinancing, but he's to hold you harmless to that debt. So I will grant an order to refinance. He's under the misapprehension that the front of the court was going to collect the $500.
Okay.
He specifically entered an order saying no front of the court services.
He said no front of the court services?
Well, he's the plaintiff in this matter, correct?
Yes.
So who filled out the judgment?
I filled it out.
Oh, you filled it out. Okay. No, you filled out the judgment with the no front of the court services for spousal support.
Where, let's say, because I went to the
right at the very top of the order. Uniform spousal support order, no front of the court services.
Okay, I'm sorry, I don't see it, and I went down to the assistance center for them, and they filled it out for me. So I'm just not really sure where I'm supposed to be looking.
Okay, so if you filled this out, both of you signed it, both of you agreed to it, But yeah, he's under the misapprehension that this was supposed to go through front of the court. The order you entered does not put it through the front of the court. That's why he hasn't paid. He was waiting for them to take it out of his paycheck.
Okay. So
I don't know whether you guys want me to set a settlement conference so we can discuss this and figure out how to get you through this.
yeah.
Okay, why don't I do that? That way I can sit down and say, how do you want to proceed? Do we reserve a motion to have this go through the front of the court? Can we make payment arrangements on that $500? And what can we do about entering an order that would hold you harmless from that debt from the repoed car? Because he was responsible for keeping and maintaining the payments on it. So I don't know if I don't know if I can keep it from dinging your credit rating after a repo.
Yeah.
Now some things, if you're applying for loans and stuff, sometimes some places will take that court order for hold harmless and say we're gonna wipe that from we're not going to consider that in your loan application. Some places, not all. Okay. Some banks do it, some banks don't. Some credit unions do, some don't. I can't control everybody's rules. So, but might be the best we can do under these circumstances. Okay. But I'll set it for a settlement conference. That way we can talk to him and figure out, do we set this to the front of the court and have them collect it? Because it needs to be collected. It's reserved. I mean, you're not losing the money. We just have to figure out how to get it in your hands. And then we need to figure out how best to protect you from the repo. Okay. Are you okay?
I'm just frustrated because
it can be frustrating.
He just keeps lying about everything, and it's just I have to keep like pushing and pushing. Like he knew that the car got repoed because he knew he hadn't paid it in 6 weeks, and he lied
repoed
to
after they repoed after 6 weeks.
I mean 6 months. I'm sorry.
Okay, that sounds more. Yeah, okay, that sounds more like a repo.
Yeah, and I told the judge at our settlement conference that he wasn't paying it, and that he told me he was selling it, and he's all this other stuff, and so and then it's like, and then it gets repoed, and now it's like he's lying, saying like he didn't know what happened, but he does know what happened, and it's just hard.
Well, he admitted in this that it was repoed.
Right.
But I'm kind of taking his email as a response so that I can give you some answers that were in the email that you otherwise might not have according to your motion.
Right.
So let's set it for a settlement conference and see how best to resolve these issues, because they need to be resolved. All right.
Mm-hmm.
Again, divorces, nobody wins. There's just varying degrees of losing. Okay. We'll get you through it. Take a deep breath. It's okay. All right. Any other questions? All right. All right. Go get a cup of coffee. Take a deep breath. And have a good weekend.
Thank you.
All right. Take care.
Bye.
Okay. Next.
Okay.
All righty.
We're in our 930s.
Mm-hmm. We've had these people quite a few times, haven't we? I've read your motion, Mr. Santos. Ms. Sanchez-Minjeras, what is going on with the parenting time?
I think last time we fixed that already. If you remember that.
Yeah, it's from Mondays at 5:30 to 7:30 p.m. and Wednesdays from 5:30 to 7:30.
Yeah, he is dropping my daughter at 8:30.
You return the child at 8:30, Mr. Santos?
Sí, eso fue lo acordado en la orden.
That's what was recommended on the order.
7:30.
Mi reclamo no es de ese tiempo. Mi reclamo es que ella falló. El informe, estoy poniendo yo mi queja, no es mi reclamo por el parenting time. Si puede leer mi moción.
So dice que la orden dice que es a las 7:30. And he's saying that it's not, the motion isn't, if you read it, the motion isn't about parenting time. It's about more of a claim.
I'm asking if it's happening because you're complaining about 2 days that were missed. I'm asking if it's happening now.
Ahorita ya no, y yo le he estado regresando. Antes de que yo puse la queja, yo la regresé a las 7:30.
No, it's not happening now because I've been returning her at 7:30 before I put in the motion.
So How many times has parenting time occurred?
¿No habrá consecuencias o está todo bien? Es mi pregunta.
So I basically have done it back in 2021. I filed with the front of the court. I also did it in 2020. I also did it now in 2024, which is currently, and so it's been 3 times. And I basically just want to know that if I can do it, if I can do the same thing back and not get in trouble for it. And that's my question now.
I have been meeting with you two every couple of months for over a year now, trying to get this parenting time normalized. My last order entered 6 weeks ago gave you Monday from 5:30 to 7:30 and Wednesday from 5:30 to 7:30 with exchanges at the YWCA. Your motion indicates that you missed that she didn't show for November 4th.
Stated correct.
And is all the other parenting time, did that happen?
Sí.
Okay, so all the other parenting time is occurring.
Entonces todas las otras veces de tiempo al padre sí han sucedido.
Hasta esta orden que ahorita puso, sí.
Hasta
esta única orden.
This current order, yes, the only order.
Okay. Ms. Sanchez Minjeres, what happened on November 4th?
We just talked about that already last time. That I didn't have car and I text him, I call him, I asked him if he can pick up my daughter.
Okay. Well, let's continue let's continue this.
I have a concern.
Hold on, let the interpreter finish.
Yeah, so 5 minutes before, and 15 minutes prior when I needed to return her. So how is that fair that I would have to pick her up 15 minutes within returning her?
Mr. Santos, sometimes car problems happen. Suppose she got into a car accident instead of a car breaking down.
No es la primera vez.
It's not the first time. And él dijo que pues obviamente los problemas de carros suceden. Entonces, ¿qué pasa si ella conduce y tiene un accidente o el carro le falla en el camino?
No es la primera vez que sucede.
It's not the first time that it happens.
Understood. But you're telling me that that was the one time missed.
En esta orden que está ahorita, sí. Pero ha fallado otras veces en otras órdenes.
And this order, yes, it's the only time, but she's also failed in the previous orders.
Okay. When we met on November 5th, did we increase the time?
Sí, lo incrementó él.
Okay.
Yes, you increased it.
Has that been because the copy of that order has not made it to the file yet.
Oh, so that's why I've been returning her at 8:30 because you increased the time to 8:30 and you also didn't add the Saturdays on there.
Right, which means the order is being processed. So once you get that order, please comply with it.
So he says that he already has it.
Oh, you already have it?
Mm-hmm.
Yeah, la tienen.
Ms. Sanchez Minjeres, did you already get the copy of the order?
No, I don't have it yet.
Well, we're going to make sure you get a copy of it. We're going to find it. But you know what it was supposed to say. Mr. Santos, make a copy of it and make sure you give it to her at the next parenting time. Normally, I do not allow some exchange like that to happen at a parenting time, but I'm ordering it in this case because I need both of you on the same actual page. Okay. Have a good morning. I'm not going to fault her for having a car problem, but ma'am, that can only happen infrequently. Make sure that this parenting time happens as the court ordered it.
I just have one more concern.
Yes, what's that?
My daughter came crying this Monday after he dropped her off because he spanked her in her butt too hard. And she came crying. And on Wednesday, before pick her up, she didn't want to go with him.
No.
But this is not the first time.
Done. I've been dealing with both of you for way too long. You're both the parents of this child. Take care of the child. Have a good afternoon. Take care.
¿Puede traducirlo?
He wants to know if I can translate.
Yes.
Está bien.
Don't spank the child. I'm going to assume that did not happen because of the stuff that's been said in the past over the past year and a half. I've learned not to believe everything that has been told to me in this matter. Again, I'm going to assume that you did not spank the child, but if you did, don't do it again. Use some other form of discipline. Have a good day, everybody.
Que tengan buen día todos.
Igualmente, gracias.
Okay.
Next.
Should I just do held?
Denied.
Denied. Okay.
Because I'm not holding her in contempt. We did deal with that on the November 5th settlement conference, now that I remember. And because she had car trouble, I can't hold her in contempt.
Got it.
I know she's done everything she can over the past year and a half to obstruct. So.
And then I'm sorry, just real quick question about another case. Hudnall, the one where you're giving her 6 months to sell the house. You want a settlement conference around the 6 month time.
Correct.
Okay.
Correct.
Just wanted to triple check on that. Thank you.
Yep.
And then we can do.
Yeah, because I've reserved the right to sell the house if she doesn't pay him.
Yeah.
I just it's awful to have to sell the house because then they've got all the closing costs and all the other stuff, and it just potentially makes somebody homeless. So if I can avoid that and still protect the interests, I will.
Next. We can do Korf versus Kirk.
Audrey, I believe this is your motion. Is there anything you care to add to it?
No.
Okay.
Not as of right now.
Mr. Korf, I didn't receive a response from you. What is your response on this?
I don't even know what this is about right now, but I know what it's about. But
this is entering a qualified domestic relations order in accordance with the law concerning your retirement plan.
Okay, yeah, I knew it was with the 401. I just didn't know if it was like going to be the final court date or what it was.
Well, hopefully it is. Once we get this done, I think all issues between you are done.
Yeah.
No offense to either one of you, but
no,
I'd like to get you through this. Now, it looks appropriate, so I'm going to go ahead and grant her order to enter the qualified domestic relations order.
Okay.
All righty.
Thank you.
So we'll get that entered and motion is granted. Have a good morning to both of you. Enjoy the rest of your lives. And may you not have any more court of interference.
All right. Thank you.
Take care of yourselves. Bye.
Right. Yep. Bye. It's done with.
I like the easy ones.
Yeah, for real. Okay.
Well, he hid the fact that he had a retirement plan.
Hmm.
And he's the one who drafted the judgment and the complaint and everything. So judge ruled that, yeah, she gets her portion of it, if not all of it. In Michigan, if you hide an asset from the other side intentionally, you forfeit that asset.
Yeah.
Mr. Sturgis, this is your motion. What do you care to add to it?
Thank you. I think the last motion, Your Honor, there was a little bit of miscommunication. And what we're here to do is just because we believe it's in my children's best interest for them to see both of their parents.
Am I incorrect in the fact that you guys have equal parenting time?
Yes.
How is, because that's the last order of the court that I found. Is there a new order that I'm missing?
No.
The last order of the court was equal time.
Well, equal time it's not necessarily equal time. I get him every other week, Thursday through Sunday. And then on the off weeks that I do not have him for the weekend, I get him from Thursday evening until Friday morning.
Okay. So it's pretty close to equal time.
Yes, sir. So again, Your Honor, I appreciate your thoroughness.
But that has been happening, right?
No, it is not.
Why has it not been happening?
And that's why we're here. For the last, heading into 3 months now.
That's right. This is okay. Yeah, I had to rewatch the last hearing.
Sure.
Because I noted you asked the judge to hear this. The problem is I'm sorry, but I don't get to choose what I get to hear. Judge sends it to me. All right. The last time the explanation was I'm enforcing that order. If she is in violation of that order, please file for the appropriate show cause hearings through the front of the court. Okay.
And so
because she can be held in contempt, as I told you.
Correct.
If she's not following through with the court order, she has the right to defend herself. But I enforced the order that is currently in the court file because there's no motion to change it. And changing it at this point may not help you. We need to get it back to what it was. She's saying there were some issues, but I told her to file a response, and there still isn't one. We last heard this on October 22nd. I still got nothing.
Nor have we. So that makes
Right.
two of
So
us.
I don't know, to the best of my knowledge, Miss Linnell, there is no reason why you should be withholding this parenting time, and it's leaning toward you will be held in contempt. And understand, as that goes, it's a nauseating process that could take a year or two, but over time, if you keep doing that, custody changes to the other side. Because one of the bigger best interest factors are the parents cooperating in the parenting time? And if you're found not to be cooperating, that's a justification for change of custody. But we've got to go through all the hoops, as I explained to you last time, Mr. Sturgis and Ms. Linnell. It is a very time-consuming process, and yeah, at times it is frustrating as heck for everyone, including me. But I spent 20 minutes explaining this to you last time a month ago, trying to tell you the proper hoops to go through. But if I remember, I did send it to the front of the court for a review.
And Your Honor, if I may, FOC has instructed me to come back to you because not only are you the ultimate authority, what I'm asking from the court and or you.
When did they tell you to come back to me?
I've already sat down and talked with them, and they said that because we're already doing what I'm asking for you to do, which is to make the school the permanent pickup drop-off location that we're already doing.
Okay.
Okay. Hold on, sir. With all due respect, I already am dropping him off and picking him up from school on a weekly basis.
Okay, what's wrong?
We're asked, and not real quick, and then also, sir, he gets bussed in when he's with his mom, so it's going to affect her in no way, shape, or form. Okay. We're just looking for the school to be the intermediary so that there's no more drama, because as of right now, just real quick, I would like to get it on record. There is a no call, no show. September 19th, September 15th, she took him from my parenting time at the baseball game, and she took him and fabricated that I left him at the game, whatever. Then on September 19th, the following week from my parenting time, she sent a text saying that she was running late. She never showed up. September 26th, she did no call, no show. October 3rd, no call, no show. October 10th, no call, no show. October 17th, no call, no show. October 24th, no call, no show. We went to court on 10/22, or is it 10/25? Right. Then now the new thing, Your Honor, is now Colton will go to the pickup drop-off location on November 7th. He puts his backpack on once he gets out of her car. He walks over to our car, puts his hand over his face, hands a note, and turns around, gets back into the car. Rachel leaves. November 14th, same thing. He gets out of the car, puts his backpack on.
What does the note say?
It says that, Dad, I am not coming this weekend, but I'll be there next weekend. So then the note then says, Dad, I'm not coming to your place. I'm not coming to parenting time this weekend. So November 7th, it was.
Okay, Miss Linnell, why is the child being allowed to do this?
I don't want him to do this. We have been going to the library for drop-off pickup, which he's
what punishment? Yes. Well, you said you don't want him to do this. What punishment is he receiving for doing it?
Okay. This is really confusing. I'm trying to answer this to you, but my son does not want to go. He's angry at his dad for abandoning him at the baseball field, which his dad said I took him, which I didn't, because my son actually walked over a mile to come to my house. And he said that his dad left him. I said, well, was there any coaches left? He says, no, I was the last one there. So his dad never communicated to him that he was leaving. And that is one of the biggest reasons why he doesn't want to go over there. He also doesn't pick up his kid at the library. And he's angry about that his stepmom is picking him up. He doesn't want to get out of my car. He's angry at his dad. I said, I have to take you to the library and we'll sit here and I'll wait.
Okay, would it help if I make this pickup drop off at the school?
No, the problem is his dad has not tried to reach out by his cell phone. He hasn't tried to come to the library to pick up his son. His son feels neglected, abandoned, that his dad doesn't care about him.
Over one incident?
No, this is the thing, is that his dad has been showing that he doesn't care. His dad, what you don't understand is I had several dates of him forfeiting weekends at the last minute He's done no shows at the library. In fact, most of the time that I'm there, I wait 20 to 30 to even 45 minutes for his wife to pick up my son, and they don't communicate. I'm sorry. I'm trying to explain. There's so much that's happened, and
I gave you that chance to explain a month ago, and you've never put it in writing.
I misunderstood.
I was very clear. You needed to put this in writing and respond.
I'm trying to do what you want me to do. I really am.
Neither one of you are doing what I want you to do.
I'm trying to do what I'm supposed to do. I took my son. I'm sorry. I need to breathe.
I did this for 20 minutes last motion day 2 months ago. All right, the library seems to be a problem.
I'm asking him to communicate.
It's a problem because your son is not complying.
He doesn't.
He has no right to. He has no. Does he
going-
want to go to school? Because he doesn't have a right to choose that either. He goes to the parenting time that's ordered. I'm not having a 14-year-old run this show.
He's not. He wants his dad.
You just said he writes that note, and you're allowing him to run the show. Enough. If plating it, I'm going to change this to you'll pick up and drop off at the school when available. So I will change that. That portion of this I will grant.
Sir, I have not been able to respond. I didn't know. I was waiting for an FOC.
Done. I gave you the ability to respond. I told you to respond. You didn't respond. That's a non-response. So I'm going to grant the motion to change the pick up and drop off to the school. Have a good morning.
Thank you, sir. Yes, I get to see my son. I get to see my son.
Maybe not. We'll see if we got a 14-year-old running the show. God help you having a 14-year-old that doesn't want to be with you. Oh, well, we'll see, because maybe he does. Who knows? Next. Yeah, I had to rewatch that hearing. And I'm like, I was so clear about what they both needed to do. 6-5 DO, which is a case without minor children, despite the fact that we've had to deal with 2 minor children. Well, we had to deal with 1. Now we have to deal with a second.
Yes.
You and Jeremiah have long since split, correct?
Yes.
This child is 1 month old.
Yes.
This judgment, the judgment of divorce, was entered only about 2 months ago. So you were pregnant when this judgment was entered, correct?
I had my final divorce court in March, but I didn't know how the process went. So
the judgment was entered in September. I noticed that the entry stuff happened in March.
Yeah.
So you didn't know you were pregnant when you did the testimony, correct?
Yes.
Okay. All righty. Normally I'd have a file. You know who the father is of this child?
Yeah, same. Juan Viramontes. Same as my one.
The same as the other one we said was born out of wedlock.
Yes.
Okay. I'm not even gonna. At this point in time, Ms. Pacheco, please raise your right hand. Do you swear the other right? Yeah. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in giving testimony?
Yes.
All right. You and Jeremiah separated, oh gosh, how many years ago? In 2021, correct?
Yes.
And you have not physically been with him since that time?
No, I have not.
And you have had another person in your life, significant other, who has born one child about, oh, gosh, a little over a year ago?
Yeah,
The
he's
child was
1
born.
year old.
Yeah, and this child was just born last month, correct?
Yes.
And he is definitely the father of this child.
Yes.
And due to timing issues, the child was conceived during a marriage.
Yes.
Okay. And this one was born after the judgment was entered.
Yeah.
Okay. I'm not going to order DNA. I'm triggering that one clause in the DNA statute that it says the court shall order DNA if it will assist the court. I don't think DNA is going to assist the court in this matter. I think timing assists the court in this matter. Let's get both of these kids to the correct father. because it ain't your former husband
Yeah, exactly.
who you haven't seen for almost 5 years now. All righty. So I will find by clear and convincing evidence due to lack of contact and that this child was born out of wedlock. All righty. You have a great day. Take care, Ms. Pacheco. Let's hope. I'm hoping this is the last one, right? You're not pregnant now, are you? Okay. Okay. Because according to certain policies, if a child's born within 10 months of a judgment of divorce, the husband is still the father. So we have to go through this again. So let's not do this a third time.
No.
Okay. All righty. You take care. Have a great weekend.
You too. Happy Thanksgiving.
You too. Have a great holiday.
You too.
Yeah, I was trying to figure out the timing. Because I'm like, she did all the stuff that she needed to do last March. So I was questioning whether she lied to the court or not about when she was pregnant because the judgment wasn't entered till September. Like, good grief. Anyway, we got her through 2 of them born out of wedlock. Next. 0 DC. As a preeminent thing, I'm going to deny the motion to dismiss at this moment. I'm going to put this on the record. And Mr. Sokolowski, this is your motion. What do you have to add to it?
I just don't understand why we can't get on a respectful level.
Okay. And what evidence do you have of the disrespect, sir?
I have all of our messages and everything, all of our conversations printed out here.
Okay. How do you guys communicate mostly?
Through Messenger. I live in a dead zone, so I have to use Wi-Fi to contact people.
So something like the My Family Wizard app would not help you.
I'm not sure if it can run off of Wi-Fi. Then
yes, it can.
Yeah.
What? And I don't know, Ms. Fisher. I've heard of the other one. I'm trying to WhatsApp. No, not WhatsApp. What is the other one?
Ooh, I know what you're talking about, but I can't think of the name of it either. I've had the same problem as you. I've heard of both of them. The Our Family Wizard ones that I'm very familiar with.
Right. Yeah. Normally I've been using that, but the other one I've heard is quite good too.
Yeah.
There's like a $95 charge per year, but it's worth it because what it does is it monitors the communication. And if I order the parties to communicate only through that, you're notified when you're being sent a message, and it monitors the apps, and it actually flags things that are disrespectful.
We would love that.
Because there is a statute out there. It's called the Inherent Rights of the Child.
Absolutely.
And it says that neither party are to diminish the other party or allow third parties to diminish the party, because it's based on a psychological fact that this child knows they're part of both of you. So if you demean the one side in front, the child gets word of it. And we all know kids overhear things from 5 rooms away, except clean your room or take out the garbage. But you say one thing that you don't want them to hear in 5 rooms away. That's hi. It's amazing how that hearing works. But in any event, that's what I think I'm going to order as My Family Wizard. But sir, you have not met the requisite change of circumstance to change custody in the way you've asked for.
No, and I don't wish to change custody. I just want telling my son that he's going to grow up and have nothing like his dad. That's not fair to say.
And sometimes kids hear things that they think is said between the lines too. And what I'm going to warn you of is when you speak of in front of the child or anywhere near the child, anything about the other parent, remember, you're talking about the father or the mother of the child. When you're speaking to each other, you speak to the other parent as, sir, when you're speaking to her, you speak to the mother of your child. Ma'am, when you speak to him, you're speaking to the father of your child, not your ex. It does change the flavor of your communications. But My Family Wizard actually flags that stuff and makes sure that the communication is done correctly. Sometimes if it's bad enough, it will actually kick it, not let the communication go through. And then it will notify, I think, the other side that there was a poor communication, and we'll see if they reset it. Okay. So yes, and neither one of you should be demeaning this child. But we're dealing with what? How old is he?
8 years old.
8? Okay. I thought I've had enough cases today. I was thinking he was 12, but I was going to warn you about good luck dealing with a teenager because that's where he's headed. But an 8-year-old, I think he's still malleable enough. The two of you, I mean, this is an older case and it's a thin case file. It sounds like things that aren't perfect, but they've been going. You're raising a good kid, and obviously he's a kid of divorce, which means he's going to be going through tough times. I realize that this came from the gut, Mr. Sokolowski, and I realize you feel hurt. Understand sometimes children tell the other parent what they think the other parent wants to hear. And sometimes that's the feeling that they have, whether it's said or not, because they feel circumstances are saying that, not words. But I'm going to assume that both of you are treating this child well. I'm going to assume that both of you are trying not to say anything. If you want to be mad about the other parent, find a closed door room, preferably at your office, not at home where the kid can't hear. I'm not going to say you're not going to be upset with each other in the future. You can be, you will be. It's natural. Heck, when you were married, I'm sure the same thing happened. God, I've been married 33 years. I can't even count how many times, the subject of divorce has come up or, but, and there are things that are said between us and we're still married. So I understand. And if you remember, children are some of the most manipulative animals on the face of the earth. And if they think they can get something out of you by telling you something, you remember the days when even if you were ever together that, the kid could come to one of you and go, can I have? And then no. And then they'd go to the other parent and go, can I have? Dad said I could. Mom said I could. Now think about it when you two don't communicate well. That kid can manipulate both of you. Okay? But I agree with the rest of your pleading, Ms. Fisher, that the requisite change of circumstance legally has not been met under Vadvarka to do any kind of a change of custody or look at. But I am going to say, let's see if we can get the two of you communicating. So I will order my family wizard that the parties will cooperate with.
When will they need to, let's have some sort of, if you're okay with this, referee Kmetz, the time frame in which to sign up for it. Otherwise it just
within 10 days.
Okay,
but
great.
I've got to get an order out there. So maybe Ms. Fisher, if you type up that order and email it to me today, I can sign it today.
Okay.
And
I wanted to address one more thing just quickly, if that's okay with you.
Sure.
I noticed on the pleadings that Mr. Sokolowski had falsely claimed to not know where Ms. Myers lives, even though he drops off their son regularly to her address, which is
is that where you've been doing? Well, sometimes the drop off and pickup point is not where the party lives. It might be a parent's house or a sister's house or an aunt's house.
It's where they live.
You now have confirmation, Mr. Sokolowski, that that's where she lives, where you're doing the pickup and drop off.
Yeah. So, and then we don't want to have any more pleadings addressed to the first address that she lived at.
Yeah. That should be the address that you send it to, sir.
Thank you. Because I don't want to have any more issues like we did this morning.
Yeah, no problem.
Yeah. Okay.
Okay.
And also, I just wanted to, for the record, state.
I'll go with you, Mr. Sokolowski. Let her finish.
I'm sorry
about that. Yeah. Sometimes there's a delay on Zoom, and then I end up, putting my foot in my mouth. We did make a request for attorney fees due to the frivolous pleading.
I don't know if this was frivolous or not. They have an issue, and it's obvious that maybe both of them have that issue. So I'm going to cure that issue. So we're granting an order to cure that issue.
Okay.
I don't know if it was frivolous or not. Sometimes you bring attention to the court to say some of this is happening. Next time, sir, maybe attach some of the messages so we have something ability to address, but definitely use her actual address, and now you know that that's her address. What was your question, Mr. Sokolowski?
Yeah, just the address thing. I didn't have anything with it directly on it when I came down to fill these out, and I didn't feel that contacting her would get me that, so I just went with what the court had on record.
Okay,
well, yeah. Address, but...
Right, okay, then, well, actually, then he may have acted appropriately, too. The last address in the court file is what he said he used. Miss Myers, if you wouldn't mind in writing, notifying the front of the court and the court of your address change.
Yes, sir.
You guys are supposed to do that within 30 days anyway. Both of you
she's doing that today.
Yeah, no problem. And again, sometimes it's just a fact that people don't know.
Yeah, and what I wanted to correct myself was he hand delivered it to the 369.
Oh, good.
Not the one that he put on the court form.
Right.
The issue we had was that the notices, if anything had changed, would have gone to the wrong address, so.
Right, but that's the last address in the court file, so I guess that.
Yeah, we'll fix that
You know,
today.
Mr. Sokolowski's trying to act as his own attorney, and I'm not going to ask him to be perfect, even though I have to hold him to the extent of an attorney. But he did okay. You guys are all here. We're getting it addressed. We're moving you along, and 10 more years. Well, okay, 5 more, and then you got a teenager. Good luck to you.
Thank you. Thank you guys for your time.
Good luck. Thank you both. Thank you all for your time. Take care, and I'll sign that order. If you send it to my clerk by email, you have her address, Ms. Fisher?
I do. Yes, I do. Rebecca.
Okay, perfect. Yeah, send it to Rebecca. She'll send it to me, and I'll DocuSign it.
Okay. Thank you, Your Honor.
Thank you, everyone. Have a great weekend. Take care of yourselves, and enjoy Thanksgiving.
Oh, you too.
Yeah. All right, take care, everybody.
One more question.
Sure. Okay, what's the question?
Will I get like an email for